Hello, hello, hello. Come on in. Happy Friday. Are y'all ready to get to this trial? Good morning, good morning, good morning. I'm a little late this morning, but guess what? Better late than never, right? So excited to be streaming this on my channel today. Lead and I are going to be going live a little bit later today on the Young Thug case, but I'm going to do the morning session, just me and you. Starting a little late, but I'm going to start from the top. Shout out to everybody that's on the East Coast. Shout out to everybody that's on the West Coast. It's probably really early for y'all, but we are starting bright and early on the Young Thug case. What can we expect today? Well, Judge Whittaker was not playing around with these attorneys 2 days ago. Court was not in session yesterday. It is in session today. You know, Judge Whittaker is exposing a lot of the shenanigans that have been happening for months with this trial. And now we are not playing any games or getting straight to motions. We want to make sure everybody's prepared. We are ready to go. So without further delay, guys, I'm going to go ahead and get started. Say good morning to a few of y'all. And let me know where you're chiming in from. Some of you guys are in other countries. You know, I know Nurse Janice be watching us from the UK, so it's always good to see where you guys are coming from. Shout out to Eric Lawson, who was first today. And he says he believes the judge is going to dismiss the case. The law might require her to throw it out. We will see. Good morning, Tiffany. Hello to 96 Impala. Hello to Tess. Hello to EC. Hey to Audrey. So many of you guys are here. EC, I'm out of it. I have not checked my email. But no, I did not text you this morning. That is very, very strange. That is an imposter. Hello to Candy Yates. Hello to Butter. Dudabug. Hello to Trainwreck. Hello to Say What. So many of you guys tuning in. Hello to Mixed Chick. I saw you live on Leeds, or you were on Lead Side last night too. It's good to see you over here. Hello to Blue Dream. Hello to Sharon. So many of you guys are in the building. Real Talk with Rena. Good morning, sis. Hello to Black Cappuccino. So many of you guys are in the building. You guys are in England. A few folks in the UK. See, Nurse Janice, I guessed that you were going to be here. So good to see you. Trinidad and Tobago. Look at that. You guys are all over the place. I see Lower Alabama as well. Y'all tuning in from all over. And we have Florida in the building as well. Well, listen, I'm not going to hold you guys. Let's go ahead and start watching the trial. I'm going to start it from the top. We're about 30 minutes behind, but again, I don't want to miss a thing. So we're going to go ahead and get started with today's feed and get started with the trial. Let's go. Of course, Love is doing that thing again. I don't like when she does this. So they really need to look at the camera angles.
That's it. That's
okay. Thank you. All right. So obviously, I think the first thing I need to say is my name's Judge Whittaker, which I'll do, which really has nothing to do with this particular charge. But so I think the first sentence, Judge Glanville is no longer the judge presiding over this case for which you've been selected and sworn to try. That's fine. There's no objection to that. As I understand, there's an objection to Judge Glanville was removed as the presiding judge.
You're talking about what they're going to say to the jury on Monday.
I would propose as a compromise, maybe just I will be the presiding judge in this case moving forward. Then you're not to concern yourself with the change, which is already there. And I would just preface the next proposed sentence that is in a trial, none of the decisions of the court, nothing the judge says is evidence. I mean, that's true, and that's a legitimate charge. I'll give that. I would just say, let me remind you, as I assume presiding duties in this case, that in a trial, none of the decisions the court makes, et cetera, et cetera. And then with regard to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers.
Oh,
I would propose, because I am not supposed to be commenting on the evidence either, you are to disregard any comments made by Judge Glanville that may have been disparaging of any of the lawyers in this case.
Your Honor, would the court consider not instructing the jury as to anything?
If you want to think of some different language, I'll consider it, but that's what I'm thinking right now.
Thank you, Laura. That's sweet.
I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing. There's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else, then propose it.
Orally or in writing.
All right, guys, and let me just explain what's happening. We are at the top of the morning. I'm about 30 minutes behind of the live feed, and that's good because that means we have TiVo time and we can skip ahead. What we are watching right now is Judge Whittaker starting today's proceedings. What they are talking about is Monday and the jury coming back in. Now, this is actually an important conversation because this will be the first time the jury has been inside of the courtroom since the beginning, or since, all the shenanigans with Judge Glanville was happening a few weeks ago, right? They haven't been in this courtroom for weeks, right? So this is the first time they're coming back. Of course, they've probably heard that there's a new judge presiding over the case. So what they're going through right now is Love and Whittaker are talking about what are they going to say to this jury? They're showing up and they're like, oh, who's this lady? Where's Judge Glanville? And, there needs to be an explanation that is had. So that's what they're going back and forth on right now. But I just wanted to give you guys a little bit of color on what's happening there. Let's keep going.
Is the court mind oral?
Sure. Go ahead.
You are to disregard any commentary, any comments that you deem commentary on counsel for either side.
So instead of disparaging,
Yes, that's assuming that there were disparaging.
well, that's why I'm saying that may have been. So that may have been commentary? Well, I mean, right. He shouldn't, it's irrelevant whether he said you are doing a fantastic job today either. So, all right, maybe craft it a little bit more. And I understand what you're saying. So if you want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
But it should be disparaging. That's my point.
It might stay like that, but
And I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about the Judge Glanville has been removed.
okay.
Other than that, I don't have any.
All right. Okay, so we'll leave that for now. And if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
Yes, Your Honor.
All right, thank you. Okay,
Excuse me.
yes,
May I bring up a brief issue before
absolutely.
you continue? You
Uh-huh.
mentioned this morning about that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on Odyssey. I haven't received any of the submissions from Ms. Steele that came through Odyssey. I know I've talked to several other counsel, but I have polled everybody.
Okay.
So I don't know what the issue is, but I'm not receiving.
The issue is Odyssey.
Okay, yeah. So given
Um,
I can't
yeah.
investigate that today.
And I can't do anything about that. I mean, Odyssey. So,
Anybody can email the rulings out.
Okay, guys, and here's also what's happening. So we started with jury instructions. Now what they're transitioning to is yesterday, while court was not in session, Judge Whittaker had a few rulings that came out. I did see some of them myself. I think there was about 3 or 4. There were certain motions that were denied, things of the like. Doug Weinstein is saying right now, Judge, hey, I haven't seen those. How come other people are getting them and I haven't seen them? And what is Odyssey? Odyssey is the program that they're using to file these court documents, right? And what she's saying is, hey, we're having an issue with the system. That's probably why you didn't see it. And Doug's just like, can we have an email thread? It's my understanding that before Judge Glanville all the defense attorneys and some members of the media were on a email thread. So when things were filed, so no one missed anything, they would have that as a second layer. When you have a new regime, you're going to see some new rules, right? So that's what we're seeing Doug and the judge go back and forth on right now. Let's keep going.
Sure. And usually, at least the lawyers seem to get things fairly contemporaneously. I know the court doesn't always get things contemporaneously, but, and it sounds like some of the lawyers have received rulings. I know Mr. Steele received some because he filed a petition for a certificate of immediate review about 5 minutes after I filed one of the rulings as to one of his motions. So I don't know what the vagaries of Odyssey are and why sometimes it seems instant and sometimes it doesn't. But yeah, I don't have a problem with, as I file orders, emailing them out to everybody, just like I asked that y'all email me with your motions and responses. So sure, we can do that going forward.
Thank you.
Okay.
I never realized it, but this attorney's really good looking with the salt and pepper.
You're exactly right.
In this case, for some reason, it's like they have this separate cases.
Yeah.
For everyone.
Okay. So yeah, and I do not think that we have been filing our orders in everybody's case individually, every co-defendant's case individually. I think we've been filing them, like, for instance, if Mr. Kendrick files a motion and I'm ruling on that motion, I understand y'all have all adopted it unless, you say differently. But I think we've been filing it into Mr. Kendrick's case. And so that is exactly right, Mr. Short. That's what's been going on.
Yeah, for some reason, previously, we were receiving.
Okay.
So I don't know what's altered, but.
Well, maybe what's altered is that somebody on Judge Glanville's staff was individually filing it in every case, and I haven't been, and the clerk's office, I guess, hasn't known to spread it out into the other cases. So that's what's going on instead. Okay. All right. Thanks for bringing that to my attention. All right. So are we ready with any portion of Mr. Kendrick's testimony? What did I say? Copeland. Yes. Kendrick. I said Kendrick. Yes. Are we ready with?
All right. What are we doing with Little Woody?
Going back, either any kind of agreement as to what's already been testified to, and if y'all haven't been able to do that yet, then, hashing through the evidence that we're going to have to face again.
So, Your Honor, there's several statements. I think what's really helpful is when we have, and we do have some of the transcripts now where we argue, so that can kind of prompt everyone's memory. And last time we had to go through all the contested segments. What we did is the state played them in court, and then we made our individual arguments. And now that we have the transcripts of regarding some of the statements, I think we're ready to do that.
Great.
And I'm just giving the court a heads up. It's going to be somewhat maybe disjointed at times, but we just got to plow through it. And myself and Ms. Hilton did the best we could to try to figure out where we were previously. I don't believe for the uncontested issues, I don't believe the uncontested issues have changed at all. I believe I speak for everyone on the defense that we haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues here.
That works.
Do you have the ability to play the statements?
Oh, we're getting Little Woody footage.
Okay.
And
and the other thing I was going to say, the January 11th is the first, January 10th going into the 11th is the first statement by Copeland, and logically maybe that would be the first one we review, but I don't believe that myself or Ms. Hilton saw a transcript of our prior argument of that one.
Okay.
So I would ask if we could start with the other ones first.
Yeah, that's fine.
Yeah,
I think there's still one day maybe that Ms. Weaver's working on. So that may be the day you're talking about. So yeah, we can start on whatever the next statement was.
All right. Little Woody testimony, guys.
And are you going to be playing these through Zoom? So do I need to get on Zoom?
Yes, Your Honor.
Okay.
You do need to get on Zoom.
And do you have transcripts of the statements that are going to be at issue?
No.
Yes, we do have transcripts. What I wanted to know from the defense, if there were any that were litigated that are agreed upon, because I don't, if there are some that were litigated that we don't have issue with moving forward, I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right. Do you want to take a minute and have that conversation?
Yes.
I think I can answer that. I think anything that was litigated before needs to be litigated again.
Okay.
And regarding the transcripts, Your Honor, June 10th, we have the same imperfect transcript, but it's generally gives guidance. For some of the other interviews, the state has a transcript. There wasn't like an official
All right. Now,
transcript.
when you say June 10th, are you talking about his June 10th statement or our transcript
I'm sorry.
from June 10th of this year?
June
You mean
10th.
his June 10th statement?
2015. The state produced a transcript of that, and you know it's not perfect, but it gives
Okay.
guidance, and we're working off the same transcript.
Great.
For some of the other interviews, the state made a transcript at some point. Maybe I don't know who made it, but it wasn't disseminated to us, and we made our own transcript.
Okay.
So we have like dueling transcripts. Just
Okay. Well, that's not for June 10th though, right?
no.
Okay, so maybe before we get to whichever statement has the dueling transcripts, y'all look at each other's transcript and decide which one you want to go by, or if some parts of it are better transcribed on one and some parts on another, combine them and let's get the most accurate transcript.
And that's why we were playing the statements. Coerced.
Sure.
I just wanted to give.
Yeah, but
Judge Whittaker asked for a transcript and there wasn't complete agreement on the transcript.
Yeah. And there, it's certainly a lot easier and frankly, a lot faster with the transcript. So if there is a statement that I particularly need to see and hear the statement for the evidentiary determination I'm going to make.
Hey guys, so just popping in for a second. Here's what's happening. So we went through jury instructions. We were talking about all of that stuff. Now we are on Little Woody's testimony. It's coming back on Monday. It's going to be a big day. Make sure you guys are locked in here and on TLA side on Monday, because that is a big day. Today's Friday. It's a few days before that. And what's happening is they're going back and forth on Little Woody's testimony. We're getting prepared because right before Judge Glanville came off of this case, we had a big issue with Little Woody not cooperating on the witness stand. So what do they have to do? Instead of him being on the stand, we are now actually having to rely on his old interrogation footage. That's what they're going back and forth on right now. And there are about 3 or 4 of them. And then there's also some jail phone calls, right? What Judge Whittaker is doing with the defense attorneys right now, and also with the prosecution, is we need a transcript of those interrogation pieces, because we want to be able to follow along with exactly what Little Woody said. You guys remember the audio, it wasn't the best. So that's what they're going back and forth on. And Max and Simone are going back and forth on that too, because they have to transcribe everything that was said. So there's a lot of work that happens behind the scenes with some of these cases, but I just wanted to give you guys some color. Hello to everybody that's coming in. Let's go. I'm going to speed it up so we can catch up a little bit.
That's one thing, but if it takes me 5 minutes to read a transcript or 20 minutes to watch the statement, I'm going with the 5 minutes, unless there's a reason I need to be watching the video instead, okay? Because I mean, honestly, for most of these evidentiary issues, I'm not here like making a credibility determination. For the most part, that's for the jury. I'm here trying to decide, does this evidence come in under XYZ exception under the law, okay? However, right now I don't have any transcripts, so pass up whichever statement we're going to be looking at right now. If it's June 10th, 2015.
Can I email it to you? Like, I don't have a.
Yeah, that's fine. In fact, we might have some transcripts of certain of the statements, so. Yeah, under what?
Okay, looks like she's talking to her assistant there. This is interesting, guys. It's super interesting because it's just so much
Ms.
footage.
Provided our chambers with several of the transcripts of the statements that y'all had given to them, I guess. So I've got the transcript of that June 10th. And I actually have videos of some of his interviews too. I think maybe all of them, but some of them play under evidence viewer that y'all gave to me and some of them don't.
So, if you received 6 interviews, if you receive 6, 5 of the 6 are all evidence reviewer.
Okay.
And then the only one that's not evidence reviewer is the October 2021 interview.
All right. Okay. So I need to get on Zoom. Give me a second to do that.
And can I have the link as well, Your Honor?
Okay.
Should just walk off the bench.
Yeah, excuse for a brief moment.
Sure.
A little awkward silence there. Shout out to Erie. Thank you so much with the $9.99. She says, good morning, AV from Las Vegas. Good morning, Erie. And Erie, it is early over there. It is early in Vegas. You guys are, I think you're 3 hours behind us on the East Coast. So it's 7 a.m. Good morning. Good morning. Shout out to D, always in the building with the $1.99. Thank you, D. Really appreciate that. Good morning. Good morning. Shout out to one of my faves, Marie, with the $20. No comment, no question, pure love of the game. Thank you, Marie. It's good to see you, sis. I hope you're having a great day. Shout out to Danielle, who became a new member. Welcome to my squad. Danielle, you're going to love it here. You're going to love it. Shout out to DD with the $5. Said, AV said, Lee, just stay under the blanket. I got this. Yeah, I got to do more work over here on this side. Show you guys a little bit of love, my firing squad, aka
2015 statement of Mr.
aka the editing squad is always working. So, we got to give them some content to do. Let's see what Judge Whittaker is saying here.
Copeland to law enforcement, and we're all working off of the same transcript, and you're going to play the video as necessary.
Yes,
All right. Ready when you are. With regard to whatever portions of this are contested, tell me where they are, I guess, timestamp in the video, as well as what portion of the transcript, and then tell me what the dispute is, okay? Yeah, you can just come up here. Sure. And, Lon, can you shoot?
Skipping ahead.
We get let in to the.
They're setting up a Zoom right now. That's what's going on, guys.
They have proposed several redactions of portions of the interview that we did not want played. And the defense, for certain portions, wanted that portion to be played through the state. It's the state's position that if we don't play it, and they choose to play it, they can, unless we believe it's inadmissible.
Okay, so with regard to any of those portions that you just think they don't need to hear this, but the defense wants to play, I guess, have y'all talked about whether the defense intends to play it so that you can tell me whether you think it's inadmissible?
Yes.
Okay.
So I just want to order the jury that's
all right.
Who we are. So with respect to the June 10th interview, the first section, I'll just go in chronological order, that there was an objection. The defense wanted to redact timestamp 1019 to 1011. I guess I'll let defense counsel explain why they wanted
1019 to 1011.
101911 to 101941, which is page 61, line 22 of beginning at page 61, line 22 through page 62, line 14.
Okay, so we're going to watch a little Woody video. That's what they're talking about. And that's why we're setting up the Zoom. That's what Judge Whittaker is watching, and they are arguing the defense on if this piece is coming in.
Man, I need a go-to page number on this computer. So I have to just scroll and hope I get it right. All right.
Yes, sir. Can you repeat what you said about this segment? Who wanted what?
This is a segment that
Thanks, Tavis.
defense counsel, you want it redacted, but we objected to it being redacted.
Okay, so this is what you, because a minute ago you said stuff you're not gonna play, but the defense wants. So now you want this, the defense doesn't.
Correct, Your Honor. So the way that we had organized it initially,
I mean, if we're just gonna walk through the whole transcript and then, that's fine. That's fine. I just need to understand what it is.
yes, so this was a portion that the
You want, the defense doesn't.
yes.
Okay, and that is, I know it's 10-19-41, no, 10-19-11 to 10-19-41.
Yes, Your Honor.
Okay, all right.
And while they're doing that, shout out to Full Drinking and Half Thinking, who gifted 10 AV7 memberships. Thank you so much, brother. Really, really appreciate that. Can y'all hit my like button?
Sometimes a challenge to get it right at the right timestamp, so you just bear.
All right, let me ask. So I had just said, I don't know that we need to actually listen to the video of everything. And I mean, I can read the words on the screen, so on the transcript. So unless we also, for some reason, I need to be hearing it out of his mouth. And if I do, and there may be times I do, then we'll listen on the video. But if I don't, I can read it.
So the state's position is, we wouldn't hear from the defense, but I think it's inadmissible. So that's what we were waiting for.
Okay.
Okay, so just a little context, if we're just looking at the statement as,
My legal assistant failed to turn on my mic. If we're just looking at this, the transcript as a context.
Well, no, let me stop you. If you, for a reason, want me to watch the video, that's fine. I don't have a problem with it. I'm just trying to be efficient with our time.
No,
You mean, let me tell you what's been going on beforehand. All right, sure.
So they were discussing beforehand the Lil Wayne bus shooting.
Okay.
In this discussion. And then Kenneth Copeland on line 9 of page 61 says they did it. Who is they?
Ooh.
And they who? And he says, Shannon and them. So the first part of our objection is Kenneth Copeland giving information about the Lil Wayne bus shooting. What Your Honor
That's
needs
good.
to know from me about the Lil Wayne bus shooting is Kenneth Copeland, it's not been alleged at all that he was at Club Compound on the night of the Lil Wayne bus shooting. It's not been alleged at all that he was present, that he was there, that he had anything to do with it. So, and it is not at all clear. So it's clearly hearsay.
Uh-huh.
We need to search for an exception, and I don't know what the source of his information is. There were, this was Wayne Carter is Lil Wayne, and when his bus was shot, there was all sorts of internet reports on gossip blogs and everything else, and there's just no way to ferret out what his source is.
Sure.
To suggest that it falls under any hearsay exception.
Okay.
This is an interesting argument, guys. What is Max talking about? So remember how I was saying they're looking at, and you can see it on the screens in the background, they're looking at an interrogation video of Lil Woody talking to law enforcement. And the subject matter of that particular discussion was the Lil Wayne bus shooting, where Lil Woody was allegedly snitching. And he is saying in this video that Shannon, who is Max Shard's client, was responsible for that bus shooting. Now, what Max is trying to do is he's trying to get that statement excluded. Why? Because, we talk a lot about hearsay over here. What is hearsay? It's an out-of-court statement made for the truth of the matter asserted therein, right? So it's usually something that someone else said to someone else, right? So it's like one person says a statement, but it's not the declarant saying it, it's someone else saying it, right? So in this footage, Max is challenging that because how does Lil Woody have that information? Is it firsthand knowledge? Was he there? He is saying that Shannon and others are responsible, but you see why it's really important for Max to get that taken out of the transcript if possible. But let's see how he does here.
Now, I have in my notes on the transcript that page 61, lines 1 through 10, were not objectionable. That's what my notes said.
Okay, that's right.
And then
Hang on. Let's make sure that's right. That's right.
What line did you say?
62 lines 1 through 10.
So, Your Honor.
62 or 61?
Oh, well, 61 as well. Both. It starts on line 11 or somewhere about there.
So you want to ensure that y'all are in agreement that 61 lines 1 through 10 are in unobjectionable.
And Your Honor, that will, we need 2 rulings before we can answer that.
Okay.
So, initially, that was the case. However, Your Honor, based upon, we filed the notice of intrinsic acts that we would need to hear if this intrinsic act regarding the Lil Wayne bus shooting, specifically as it relates to Shannon Stillwell, if that is able to come in, then we would want to play the portions page 61, starting at line 1. Also, Your Honor, depending on the court's ruling on co-conspirator hearsay, co-conspirator statements, excuse me, we would.
Well, I can't just give you a blanket rule on co-conspirator statements. I have to know what the statement is.
Yes, Your Honor. So that would be my response to this question. What Mr. Shard just argued is that
He's not arguing anything right now. He's trying to make sure we're all on the same page. So
correct. And so what I'm getting ready to say is what Mr. Copeland is speaking with the detectives about, which is the Lil Wayne bus shooting.
right.
This is information that the state believes he received from Demekion Garlington, a co-conspirator.
That's
Okay.
where it came
So
from.
we believe that this would fall under a co-conspirator statement as in furtherance of the gang.
Mm.
So because he's telling him about an act that occurred between these gang members, and to give the court a little more context, the Lil Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Lil Wayne.
Beef, huh?
On an evening in Atlanta, several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus.
Wow.
What Mr. Copeland tells police is that Demekion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So that is kind of the context.
It's totally hearsay. It's absolutely hearsay.
All right. So what Mr. Shart was trying to sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
What are we
No
doing,
objection of it coming
Simone?
in. Yes, we have no objection of it being played.
Okay.
Right, that was never an issue.
Okay. And it's still not. All right.
So, and I don't think we need a ruling on the intrinsic. I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's intrinsic act, because it's pled in the indictment as an overt act.
Yeah.
Part 1. So
Okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demekion Garlington. There's 2 issues. A, we think he got this information from Demekion Garlington. I don't know where they're getting that from. That's 1. Other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling the beans. So there's 2 aspects to that where the state, burden is on the state, and I just don't see them needing it.
So DK, I'm sorry, y'all. It's going to take me a minute to get all the names. DK is who in real life?
Walter Murphy.
And Mr. Garlington goes by D, right? Who is little D?
There's 2 little Ds.
Who's little
There are
D?
2 of like lots of these people. Okay.
So one will be referenced as Little D from Mechanicsville, and that'll be Demekion Garlington,
Okay. So does he go by like both D and Lil D?
primarily Little D.
Okay. And he's Garlington, but he'll be Lil D from Mechanicsville.
Yeah, he also is referred to as Scarface
Okay.
in the indictment.
There's so many defendants.
And then the other Little D will be,
Quindarius Zachary, Quindarius.
and when they say Lil D,
From Cleveland.
Cleveland. All right. So we got
And they also call him Sick D.
Sick D,
Sick
Lil D, or
D.
Sick D.
The D is now sick.
And he'll be from Cleveland. Okay. Thank you.
And Your Honor, it's not speculation that Demekion told him this information on page 61, line 22 through 24, Mr. Copeland says, little d, that's how I get all my information through little d. Which little d? D ain't, and they clarify, he says Mechanicsville, which is the Michigan Garlington.
Okay.
I'm just not reading it that way.
All right, let's see. So maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
Can y'all hit that like button for me?
And you're right, so start little.
Spread the word, spread the word.
Sorry, about 10:18:52,
Okay.
but we're going to be listening around 10:19:12.
All right.
You got the Zoom set up. Here it is. There's little Woody.
They were on Shenanigans. BK right here for the last name. Yeah. What about Libby? That's how I get all my information to Libby. Yeah, we can't yeah. See, he's not gonna be able to tweet all day. Twitter is, man. This how he gonna do all day. I mean, he gonna be everybody. He'll reach everybody. Everybody. I mean, talk to him. You know what I mean? So I would say, hey, right there. I call you right now. Everything I'm going to get right there. What's going on? So, well, I don't let it deal about here, bro. If you know you ain't gonna plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Ted too. Say I'm gonna kill Ted. Nah, do it. But why don't you kill Ted?
Ooh.
And I can replay it around if you need it.
Ooh.
So, Your Honor, this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspirator statement, every case I've ever read involving a co-conspirator statement, appeal. Declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder, and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting and who did it. They ask him, what about Lil D? And I'll concede it seems they're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Michigan Garlington, I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot, he gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Demikian Garlington told me, and I know you don't need an exact date, but Demikian Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect to hear, yes, Demikian Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then, of course, again, it's spilling the beans when it really comes down to it too, because there's no context that would lead anyone would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, in context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination, and it falls under 801 D2E. And of course, the burden is on the state to arm you with that information.
What's the judge gonna do? That's a good argument. That's right, barbershop. It's right, cowboy. It's not evidence.
Yes.
While you're reviewing this, with all due respect, I want to renew my motion for mistrial.
Ooh. Okay, OG.
The entirety of the record up to this point.
I always wanted to be a gangster.
I think it's impossible for you to jump parachute into this I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people, issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I, want to clarify that. Everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we were replowing this.
No,
Go ahead.
Okay,
But yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling. And that's something for potential appeal. That's true in every case. And I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial, or I find out as the motion is being presented. So yes, it would certainly be easier if I had heard 6 months of testimony that came before this, but I don't think it is a basis for mistrial.
I disagree entirely.
Oh, Bruce.
Know the basis and the people's names and the testimony had you been the trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled.
Okay, look at that. So we're up. We're starting. It was a little slow this morning, but look at that. Bruce Harvey, the OG, stands up and says, Judge, even though we're going back and forth on this piece of evidence, because look, we have to explain to you what's going on. We have to explain, 6 months worth of testimony that has already been listened to. You're not familiar with it. You don't know these kids' nicknames. We have to explain that to you. You're parachuting in. Bruce Harvey's going, and he's right. He's just like, it's impossible for you to be brought up to speed as fast as possible. He just renewed his motion for mistrial. We're probably going to get 1 or 2 of those a day, right? So, because again, this is a very unique scenario. This is a very unique case. So Bruce Harvey stood up and just said, Judge, this is why we should have a mistrial. And she's saying, nope, we're still going to do it. We're plowing through it for a reason. I will be brought up to speed, but it's not enough for me to declare a mistrial right now. She just denied that request. So let's keep going. It's fresh early in the morning. We've only been watching it for about 52 minutes in, and we already have a motion for mistrial. Let's keep going.
Mr. Steele.
Could you mind, as you're making this analysis under OCGA section 24-8-801 D2E, I'd like the court to just denote that in a good case is, that I think is a good case, is Stafford, STAFFORD versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa, 865 Southeast 2D 116, 2021 case. And the reason, I'm listening intently, I don't mean to interrupt, but the state's belief of the law over the past year is that any statement made by a supposed co-conspirator to another co-conspirator who speaks with the police furthers a conspiracy. And as Mr. Sharp said, that is just spilling beans unless it really does something to promote the conspiracy. So even what the state just said, I get my information from Mr. Garlington. My point is that doesn't help the state, because if I'm in a conspiracy with Mr. Adams to steal a pencil, and I tell Mr. Adams, I stole the pencil, or Haley, who I'd like to introduce you to, stole the pencil as part of our conspiracy, Mr. Adams, then repeating that to law enforcement, doesn't do anything to assist us. Now, if he said, cover for Haley, give her an alibi, that is different. So the point I'm trying to make to you is, I'm not so sure that there is a conspiracy. Like, I'm just telling you, I know you're working hard, and it's all appreciated, but Mr. Nichols hasn't really been mentioned in this case. He was not mentioned in an opening statement. He has one little section on I can't remember the year, 2014, but I don't know the year, small drug case. Otherwise, he's not mentioned. And then I'm not trying to argue for the Honorable Ms. Westmore and Mr. Harvey, but That's why he's always asking for 105 instruction. But the point I'm trying to make to you is this exercise also has to inject, if you don't mind, why the state is saying it furthers a conspiracy. Just getting information does not further a conspiracy. That's my point. Thank you.
Thank you.
If I can add some additional facts, because I don't want to. This is not the only time in this interview that Mr. Copeland talks about the Lil Wayne bus shooting. So this is the first time he actually talks about the details of the shooting. At least 2 more times throughout the course of this interview. So this interview is 9 hours long. And so in the course of that interview, he gives more and more details about the shooting.
All right, maybe point me to the parts of that. So I don't know if you were able to pull up Stafford or if you have it, if you've looked at it previously, but what it says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements, and that is essentially that even where there is a conspiracy that has been established by a preponderance. No, I lost my place. Hang on.
She gonna let this in?
Here it is. Hearsay statements that implicate a co-conspirator but do not advance any object of the conspiracy, such as statements that merely spill the beans about the conspiracy, are not admissible. So if you can point me to how this advanced the conspiracy, and I understand your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them. And that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy and not theoretically where
Simone.
your evidence is going to show that.
Simone.
Yes, Ron. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015, all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of 2 events. So
she's scrambling and
Lil
scraping.
Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that. Evidence has come in that members of YSL, specifically, have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the 2 of them, in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And
guys, real quick, let me stop the show because someone has entered my chat. Shout out to HVM, High Value Man. I haven't seen you in so long, brother. Thank you so much for the $100 super chat. He is your stream sponsor. So while we are watching Simone right now, scrambling and scraping to see if she's going to get this evidence in, and she's giving the judge a history lesson in hip hop, she is letting the judge know who Birdman is. She's explaining the history, the beef between YSL and Lil Wayne, right? She's explaining that quite poorly. You can even see the body language. Look at the judge's body language. We are watching all of that, but if y'all could do me a huge favor and type HVM in the chat. It is so good to see you. Happy Friday, my friend. Thank you so much for becoming the stream sponsor. You guys know, like, I like to stop the show whenever I see him. Super, super generous of you. HVM, thank you. And I hope you're having a great, great, great Friday. Let's get back into this argument, but just definitely wanted to acknowledge you and thank you so much for your generosity.
We believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL like just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe that he was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we
And
do not
his
have any
peeps.
evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news, it promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him. How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across. It made headline news. It made news.
That may be. Again, how does then apprising Mr. Copeland
Answer
of
the
it
question.
further the purposes of the gang?
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
Promotes himself as YSL?
As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
No, he doesn't. Simone, come on.
No, we do not have any evidence of him posting on social media YSL shooting up the bus.
Okay.
What you gonna do, Judge Whittaker?
All right, so we are then looking at '61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So, Your Honor, then there's, and this is where I'm not sure what the state's, 62, the beginning of, I'm sorry, the beginning of 62, they just talk about Lil D from Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong
No,
opinion.
y'all all said nobody cared if that came in, 1 through 10, nobody cared.
Yeah, 62, 1 through 10, I agree. I don't have a strong opinion. I was just trying to understand what, if the state had an opinion about that, if all of that was coming out, or all of it was coming in, the 1 through 10 on page 62.
I think Max won this argument, guys.
No objection to it?
Yeah, no. 62, 1% of the state is okay with coming.
Okay.
Okay.
I'm just trying to clarify.
All right.
But then starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about, potentially Jeffrey was going to
Yeah.
have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is, he entered a plea in this case.
Your Honor, that portion is redacted.
Okay.
62, line 15 through 22 will be redacted.
All right. Next.
All right, it got out. It's excluded. Shout out to Max winning that argument.
I believe the defense wanted next page 62, line 23 through page 70, line 16 out.
Tell me again, 62,
Page
line
62,
23,
yes, line 23 through page 70, line 16.
16, okay.
So now we're looking at the next little Woody statement that the defense wants taken out. The judge is reading it. It's likely we will be able to see that statement, and we're going to see if that's going to come in or out. Thank you guys so much for shouting out Atrium. See if I can skip ahead here. It's taking a while to read. It's taking a grip to read, actually.
I don't recall having a blanket.
Okay, here we go.
Anything, but I don't recall having a blanket objection. Now, there's certain parts in this transcript as a whole, and they're coming up not to 72, but a little bit after 72 that go back to Lil Wayne's bus shooting. And our stance is all that is covered under the last ruling. I mean, all of it's the same general situation. But regarding these pages 61 to 72, what I have is I objected to 70, page 70, lines 16 to 19, where it's just Investigator Dennis identifying, it's not Copeland talking, but Investigator Dennis says,
If Shannon is a shooter.
Shannon is meaning Jeffrey's shooter. Why would he put these?
Yeah.
I think that's appropriate to have the investigator, just put that out there. And then after that, line 72, lines 5 through 13, again, it's Investigator Dennis, kind of giving his theory on everything in relationship between Kenneth, Jeffrey, and Shannon. And it's not needed to add context to anything, it's just kind of him giving his theory.
All right. So does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16?
That's what
Anybody have an objection to that?
Okay, I'm sorry. No.
Nobody has an objection. Speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, line we have 17 through 19, we have no objection to.
So
that.
redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, line 17 through 19.
And also, I believe what he just said, page 72,
Lines 5 through 13.
no objection to that.
All right.
Oh, 72.
Okay, next.
All right, what's up next?
The next portion that I had initially was page 70. The defense wanted redacted was page 72, line 14 through page 73, line 21.
All right, does the defense still have an objection to that?
The 73 line,
No, 72, 14 through 21.
No, 72, line 14 through 73,
Oh.
line 21.
Okay.
That's funny, Dan.
God bless you.
No, I'm.
God bless you.
Speaking for Mr.
Okay.
Silva.
Anybody, any of the defendants have an objection to that portion? Sounds like a no.
Then you're on the next portion, I believe would follow under your previous ruling, which would be redacted, which would be page 73, line 22 through page 78, line 16. So
Okay.
I don't think there needs to be any further discussion.
All right. Look at us making progress.
She loves being efficient.
Yes.
I usually have read Stafford just address something briefly related to the case side. Your Honor, in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police.
This guy never talks.
So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on the stand who can be cross-examined, so it's not what he said verbatim to Detective Dennis, it's obviously what he stated to other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy, but that's not the situation we have with Mr. Copeland, who's live across the table.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you.
Yes, sir.
All right.
Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a confrontation clause violation. what the
Right.
attorney's talking about.
But that wasn't what I was using it for anyway. So
It was hearsay.
yeah. Thank you. All right. So what's our next portion of this statement?
The next portion that we have, Your Honor, that the defense wants out is page 140, line 11 through page 143, line 16.
Ms. Hilton,
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, and I believe the full redaction that we agreed upon last time, I have it correct. Is page 88, line 23 through page 92, line 20.
So y'all agree that that's out?
Yes.
All right.
There's a small portion that we can play, which was page 91, lines 20 through 21,
91.
lines 20 and 21.
Everybody good with that?
I don't know. I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're going to
Yes.
do that? Well, they can figure that out. All right, so then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16. Yes.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140, is the, 112, 24 to 114, 25, we agree on that?
Page 112, line 21 through page 114, line 25?
Yes.
Yes,
And y'all agree on that being out?
out. Yes, Your
Okay.
Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being,
22, I'm in concurrence. And then 129, I have 129, 20 to 130, 20 possibilities.
I have 120.
And guys, for those that are just popping in, what we are watching, we were watching a ton of stuff. But really what we are focusing on is Monday, and they are talking about what evidence is going to be put in front of the jury. And Little Woody's going to be back on Monday. So we're kind of parsing through all of that stuff right now. And it looks like they're getting through it fairly well. So Max and Simone are agreeing on certain statements that Little Woody made in this police interrogation footage that is not going to be put in front of the jury. So far, so good. I mean, the good thing about this is a lot of it is focused on Shannon Stillwell, and that is Max Shard's client. So that's why they're really, really going through this, because we're focusing on the statements that were made in regards to him in particular. So they are agreeing on what's coming out. A lot of folks are like, hey, how are you able to skip ahead if this is live? I'm about 40 minutes behind of what's actually happening. So, you know, we all know CP time over here. We all know CP time over here. But of course, also we get a little bit of TiVo time too when I stop to explain what's going on. So I just wanted to give you guys an update there.
29, line 18 through 131, line 25.
Is out by agreement.
Out.
Okay.
131 line 25?
Yes, sir.
Okay, great. All right. On the same page.
All right, so now I'll read 140:11 through 143:16.
For this part, I want to give a little bit of a brief context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I want to give the court that context before we go into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19th, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19, 2021.
Couple things. To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Copeland, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child. He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It has no probative value to this case. My client, the fact that he is meant to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in his indictment. I believe he's charged with 2 different counts of possession of a firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value. of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay.
And 403.
And 403.
So for relevance, Sharon, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leaves. So I don't think
that's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get to the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as relevance, Sharon, we believe that the simple fact that he gets the gun from Shannon, or it's Shannon's gun, that he has to shoot back at the opposition gang shows, one, that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does as a part of their enterprise conspiracy. They pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. And this story, which really adds nothing to the state's case, the idea, it's evidence of passing guns around. I mean, they're going to have direct evidence of Madari Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamel Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just the
okay, because it really can't be 404B if it's intrinsic. And you just said you agree it's
intrinsic. Well, she got you, Max.
That the shooting itself, the shooting involving Kenneth Copeland, it seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that.
Simone won that one.
What's our next section?
Hey, Ari.
Defense wanted out was page 188, line 9 through page 189, line 9.
All right. Good morning to everybody that's coming in. We are getting ready for Monday. All right. Here's what's happening. We're going through all of the Lil Woody interrogation footage right now, and the defense and the prosecution are trying to see what pieces are coming in and what pieces are coming out. We've gone through a few of those pieces so far. I think we're on like the 4th or 5th argument, a little bit slightly behind in the live feed, but the judge is determined to get this done today because Monday's a big day and Lil Woody will be back on the stand. That is what we're watching. Max just lost that last one, but let's see about this next one. I'm gonna skip ahead while they read. It's real quiet in that courtroom.
And so whatever.
All right, here we go.
So, Your Honor, this discussion, the context of the discussion is really times. And so whatever he says, he does. And the context, in bigger, larger context is whatever Jeffrey says, she does. That is a broad character statement in the court. Whatever crimes Jeffrey says Shannon commits, that's a broad character statement that would violate 404B, bad character evidence, and 403, Your Honor, as well. But then, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me it's getting paid nothing? D. So.
Well, no, then Kenneth Copeland says no.
Oh, I'm sorry. You're right. And then they just talk about
How Kenneth Copeland can't flex because he doesn't get all this stuff.
right, and how Shannon's broke.
Yeah.
So I just don't see the relevance of this. I think it invites, it's speaking in very broad terms, and it's just broad bad character evidence about Mr. Still.
So it looks like Shannon told Copeland, and so it'll be a party opponent statement because he says,
Shannon told Copeland he doesn't get paid.
correct, for the stuff. But what, more importantly, not even the get paid or not getting paid, but that Shannon does anything Thug tells him to do.
No, the Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor. Let me be clear. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion of what he says in here, which is he does everything that Shannon tells him to do.
That Thug tells him to do.
That Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator member of the gang is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why in the gang.
I'm sorry, I'm not tracking, and I think I might be missing. Where are we getting that Shannon is the source of this?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video, he kind of whispers to him, and on page 189, detective says, he said Shannon. Shannon's telling him, but you have to see the video to see it in context, so we can play that portion.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever?
Uh-oh, Simone, here we go.
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mhm.
They have known each other.
Yeah, that's established in the evidence.
Established in the evidence. And so really that is his personal observation of what he notices between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So that's what we believe that's his source of, now that's his lay opinion about what he's observing.
Anything else, Mr. Short, on this?
No, no.
All right. I am going to permit this over the 401 and 403 objections. And I don't believe, I mean, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next one?
All right. Looks like Simone won that one.
The next one that we had that the defense wanted out was page 202, line 14 through line 20.
And we are in agreement, it's held in 197, 14, 199, 4.
Yes.
Did I get it right? For your notes, the exact line?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
You said 202, 5 to 19?
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was gonna say the opposite, seems a little.
Dang. All right, well,
I agree with this whole.
darn it. Okay, I'm just gonna have to get a fan up here. Well, it's not up here. Okay.
Your Honor, heat does rise, so it may be hotter up on the bench.
Okay.
Wow. A little humor.
Yeah, we can have a convenience break. Sure, let's break for until 10:30. That's down as far as it'll go. It is
Okay,
just-
so it looks like they took a break. Let me see if I can skip ahead. Yeah, we have some TiVo time, so they are back from their break. All right.
Before I have. If you're amending what you did before, that's fine, but before I have for you, page 202, 14 through 20, what you're saying is.
I have 202, 5 to 19, but either way.
Okay.
Not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot at them. And then Kenneth saying
Shout out to
Shannon
the.
doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. Get into arguments with people and they shoot at us. Again, not talking about a specific act, just generally, and Shannon ain't going for it when people shoot at us. I mean, all of this is just.
All right, so
very
let's
prejudicial and harmful.
kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but what I'm saying, me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say,
I never did
shoot back at him. And so he's talking about that particular.
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay. And
Yes.
so,
So we believe that's relevant, that furthers what he just said earlier in this interview about Shannon not liking the fact that he was
Right.
not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309, Georgia 15, which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abuses discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what they cited.
309 Georgia.
15.
yeah, I mean, it's basically just for the proposition that owning guns and having guns isn't character evidence.
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your Honor.
Okay.
So the
All right.
fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court trial.
Anything else, Mr. Short?
I'm trying to
Okay.
look at Lyons
Sure.
real quick because I have a suspicion.
You have a,
Lyons a convicted felon?
Your Honor, I don't know if Lyons was a convicted felon, and I have not found a case in which the court distinguishes if an individual is a convicted felon, that imputes more bad character than not. And I don't know if that's the argument that Mr. Sharp is about to present to the court.
Well, okay. So I'm reading Lyons very quickly, but it seems that in Lyons, there was an argument that the gun in the picture could have been the weapon used in the crime.
Mm.
I mean, that's not what we're dealing with here.
okay, but is it standing for, well, whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence, do you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So we don't have the same probative value, period.
And let me just quickly explain what happened there, guys. So what you're watching is another piece of evidence that we're trying to take from the Little Woody interrogation footage. And remember, Max is representing Shannon Stillwell, right? So Simone had just, presented something that she wants to keep in. And in order to support the fact that it should stay in, she talked about a case, and that was the Lyons case, right? Now, Max is kind of arguing a very, very minute point, but what that point is, because they're looking at the character evidence if you have a gun, right? And Simone is basically saying that it should come in because it shows that these guys would share guns, they would, pass them around, they would use them. And she's trying to bring that piece in just to support the fact that they should all be, convicted of these crimes, right? Now, Max is like, okay, well, what is the law generally in Georgia, right? The judge is saying, okay, Max, I want to hear your side of it, but what cases do you have to support your side of it, right? So it sounds like she doesn't like to waste time. We've seen that from Judge Whittaker, right? She's basically like, hey, you guys need to go do your research if you're gonna duke this one out, if you're gonna argue about this one. So she is actually challenging Max to do a little bit more research on it and take the issue up a little bit later. But let's keep going.
All right, well, how about we come back to the 14 through 19 portion of this page with the gun.
And I never argued about the first part of 5 to 13. I don't believe I did.
Go ahead.
But again, we got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't
fire back or retaliate or do something. I'm not following how that's relevant.
Okay.
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs. So from 2015 to 2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for. Okay. I am going to permit the 5 through 13 portion in over the objections and don't find it substantially more prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So Hall, Hall versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three, 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia.
Appeal
Oh, app. Okay.
210.
Okay.
And it's 348 Southeast 2D 736. It's 1986.
Okay.
And Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips Court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after it's italicized. The prior conviction was
Thank you,
admitted
Thrivens.
into evidence over the objection of defense counsel because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And
I
to say that he runs around with, I'm sorry, did I?
Go ahead.
To say that he runs around, he being Mr. Stillwell, runs around with a gun at all times, his conviction is back. It's in this case. Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction back to like 2012, I think, but I'm not sure on that. I don't want to make that right.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right. I'll take a look at it over the lunch break and give the state a chance to come up with their own case law on that. And so, I mean, are y'all kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts.
Okay.
And essentially, Mr. Copeland saying, hey, he always illegally carries a gun as a possession.
Okay.
And of course, that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific
All right.
charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice.
Right, because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
This man is known to carry
this man
guns.
always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, this guy's everyone knows he's the biggest killer of all time, you know, and it's just like, well, that's a problem in front of the jury.
Well, it's a, okay, so I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it up after you've presented whatever you have and after lunch.
Okay, so that one's undecided.
I'm not sure that being able to say, I know, you know, from my own personal knowledge of him, that he typically carries a gun is excludable simply because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know, y'all come up with something and hand it to me later. Let's move on to the next thing. We'll circle back on that one.
All right. What's up next?
The next one.
Ms. Hilton, are we in agreement on 21320 to 21416?
Yes.
You agree, we're in agreement.
That it's out. Okay. All right.
And I just want to confirm, we're in agreement 220, 11 to 21?
I have 220, 12 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to half of 15, so it's stop after.
Either?
Yes.
Okay, all right, we're in agreement. And then 222, 17 to 2.
Shout out to Full Drinking and Half Thinking. Thank you, brother. I'll catch that in a second. If y'all got a membership from him, please say thank you.
All right, let me get to that.
And I'm gonna skip ahead. It looks like they're getting close to their lunch break.
I'm just going by the transcript I have and the amount of writing I have on it. I don't know if the transcript, this might be one that we need to give the
Okay.
audience.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involving the game was shot up
Mm-hmm.
and that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all. So I think this is just a big lie. But that being said, the game had nothing. I mean, this is not listed as an overt act. The game is a gentleman named, I think his name is Jason Taylor. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter,
Mm-hmm.
a number of other artists took sides, and we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game. That, you know, if he comes here, he gonna have to come see me and he's threatening him.
That is interesting. That is interesting. And shout out to Cowboy that caught this. And again, if you got a membership from Full Drinking and Half Thinking, please say thank you to him. That is super, super generous. He's been gifting them all morning. So Full Drinking and Half Thinking, really, really appreciate you. Always supporting me, always supporting the lead. Really great brother. But I do want to just point something out, and Cowboy caught this. This is the rapper, the game. Okay, this is what we're talking about now. So this is actually really, really intricate. You see how Woody was in this interrogation room talking about all of these things, right? Hours and hours and hours of footage, and he's just spilling the beans on all of it, right? So I just wanted to pop in to clarify it is in reference to the rapper, the game.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them? And Kenneth says the Game was fixing to get his ass shot up, and Thug would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out of his.
It says if Thug would have told Shannon to do it, because then it says Thug told him no.
Right, and he says Shannon told me out of his mouth he was up.
Where does it say Shannon told me?
When you hear it, so when you hear where it says indiscernible. So I think the last time we heard this portion, there was a lot of dispute in the courtroom as to what it said. So we need to play it.
All right.
And
I also,
that's the context that's right.
Okay, but so this is essentially somebody not doing something. Maybe y'all want this in. Well, you wouldn't, but Mr. Williams might.
But
so why is it relevant? Because
so it shows that Shannon's ready to do anything on behalf of YSL is
right.
why we believe it's right.
All right.
and that's exactly why it's problematic.
Okay, it's problematic. Why is it evidentially inadmissible?
Well, because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action.
Character.
Okay. Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Well,
Come on, Max.
yes. Well, not only stands ready to act, but wanted to act. On it's just like,
All right.
it's bad character, and he's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character, and I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible, evidentially, character evidence to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such tasks or anything that the alleged leader says.
And Your Honor, also, I'm going to defer to the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I'm hearing was shot up, and if that's what's being said, I would ask that the state provide us with some reports about something happening to the game at some point. Your Honor. Because I don't know anything about that.
John, can I add?
Yeah.
Flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him.
What?
They did not call Mr. Brian Williams.
Okay.
On their witness list. They stated at one point they were going to call him because we have a short list.
Shout out to Steele. That's actually an excellent point. You know what he's saying, guys? He's talking about the witness list, and the two names that he's talking about Lil Wayne himself being on the witness list, and Birdman himself being on the witness list. Brian is saying that the state said that they were going to call these two rappers, haul them into court, take them off of their jobs for the day, and bring them into this courthouse so we can talk to them and put them on the witness stand. That is what Brian Steele is saying right now. Very, very interesting.
And evidence came out that, and I don't know how familiar the court is but when people are in the entertainment business, they advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool.
Mm-hmm.
So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell was going to do this. There's zero evidence. I've interviewed these people that the game, it's a band. It's a musical band. Game is GAME. That they were shot at, that they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and a alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah. And
And then the gang experts, quote unquote, come in and they say, well, this is what we said, and we found out. And I asked, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of a motion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the Honorable Court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act. It was a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Lil Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Hearsay on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Hearsay, who was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks Detective Hearsay, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site. That vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used. I raised that with Judge Glanville to say, well, how did that happen just now? Judge Glanville would not let me ask Detective Hearsay about the fact that Judge Staley coerced the plea. It was
I
not
do
true.
remember that.
The state comes back after that and compensates, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later, and Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing
Shout out to
him.
Boots.
And he specifically said, I'm going to trial, except I've been in jail for 5 years.
Right.
At the time served. The point I'm trying to make to you, and thank you for allowing me to speak a long time. I didn't expect to go into all this, but it is, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this, portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea. My understanding is, and I read what you had filed. I didn't know that there was anything still pending in terms of anything for me to decide, because that's already happened in this case. And even if his later plea was an Alford, we all know that an Alford plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness, but that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County Jail. And I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case. So he's not here. We can't cross-examine him. The tendering of an Alford plea or a guilty plea or a NOLO plea. NOLO plea can't be used.
Well,
ignore that.
right.
A guilty plea or an Alford plea. The person, Mr. Williams, has the right. That's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, Overstreet versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 214, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams. So
let me ask you something. So what he is indicted for in this case, this
Rico.
Right, this, you know, this instant case, that's not what he pled guilty to before Judge Staley and then entered a Galford plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay.
He being, I'm not,
He Winfrey.
yes, that's exactly right. But, you know, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in, because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The jurors have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this, when the state is telling you, and I went backwards, I guess, but you know, the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against the co-conspirator, a statement against his interests. He's not here.
Ooh.
That doesn't apply. That man's not on trial.
Okay, so I'm asking what's pending for me to decide.
What's for you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you really, why I stood up, I just want you to understand, it is not like this has been proven. You know, the game and that they were shot at, it's just a theory. And I understand you're saying, yes, then they have to prove it and it's up to the jury. I agree with that. But I don't want you to just buy into like, oh, this is so important because it's already in evidence and the state needs to, you know,
Okay.
evidence and prejudicial.
All right, thank you. Okay, so I'm not even sure where we were
I
with
think we were
regard
gonna
to this.
play it.
Yes.
We're just-
Exactly. Okay.
Your Honor, we're gonna start just slightly before at
Back to Woody, guys.
45. And this will probably be somewhere around page 222, maybe around line 1.
Well, hell, she not taking no shit. What do you mean? She not taking, those not taking no shit from her. Well, this, nobody else, care about nobody else, you know what I'm saying? Those don't take shit from nobody. Well, how does it be for that again? The game is, shout out to those who told Shan do it. Shan told my mother, he told that Wayne. Just give me the word. Yep. And those don't know. Say, come on, the GD, I can't, Nilsson, Hearsay, something like that, he can't be. You know what I'm saying? He stopped. I mean, I ain't here to play. I mean, I just don't want to go to jail. I mean,
And we're gonna stop it at 12:17.
All right, if y'all want me to figure out what got said, then I'm gonna have that tape. I'm gonna have to slow it down. I have no idea. What you said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times. So I don't know.
She's like, I do not understand what the hell Little Woody just said. That is hilarious. She said, we're gonna have to slow it down. Even Thug was laughing at that.
Yeah. Yeah. Not the whole thing, just that part that is kind of hard to, like line 19, the game fixing to get their ass shot up, as I think. But after that is what the. Before you hit play, is the sound coming out of that little white speaker? Is there any way I could get any kind of a speaker closer to me? I mean, is that where that's coming from?
I had Nielsen, Hearsay, something like that. He can't be.
It may not move far. In which case, that's not gonna do much. So just put it back where it was. Thanks, though.
Your Honor, I don't know if we can play it slower in evidence review, but I can
Well,
play it
just-
multiple times as evidence reviewer.
I'm trying to do that. Well, she not taking no shit. She not taking drugs, not taking no shit from nobody. Well, nobody else, nobody else, you know what I'm saying? Drugs take shit from nobody. How does the people gang in? The gang be there, shout out to those who told Shannon do it. Shannon told
Alright.
everybody to win.
What I hear them saying is the gang fixing to get his ass shot up if Thug had told Shannon to do it.
Mm.
And I think it's the next.
Okay.
That's the most discernible.
Just give me a word. Yep. And Thug told no, say turn on, Shannon do it. The gang be there, shout out to those who told Shannon do it. Shannon told everybody to win. Just give me a word. Yep.
Shannon, nobody's something
The
like
gang be there, shout out to those.
if Doug would have told Shannon to do it.
How does the people gang in? The gang be there, shout out to those who told Shannon do it. Shannon told everybody to win. Just give me a word. Yep.
I hear.
A theory?
She told me out of his mouth.
Okay, well, I assume that matters. So I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth. So there's speculation involved as well, or I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, I mean, they probably are not doing police questioning thinking I need to establish exactly who everybody. It may be that through this, we don't know. And if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the president.
Yeah.
Sure.
Okay, and then with it being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
Being willing to do what Doug says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an act.
I'm not sure it's a crime to be willing to do it if you don't do it
No,
unless.
I'm saying waiting, not, I heard waiting, like he was in, I don't know, I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I will re-listen to it. Okay, let's move on to the next one.
That was hilarious.
The next one. We agree with based on the court's prior ruling.
Come on, Simone, talking to the mic.
Line 5 through 233, line 22.
I think it should start at 230, line 20.
Okay, looks like they muted the mic because she's talking to her assistant.
Yeah, 230, line 24.
Well, 230, line 20 says, this is Mr. Copeland speaking, that car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, Ryder. Page 230, line 20.
And where did you say it ended?
To 38, line 20. Really, 239, line 2.
Thank you guys for hitting the like button. Let me see if I can skip ahead, guys, because there's a lot of dead silence.
Okay,
All right,
we're in agreement with that.
all right.
Next, I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3, where we get there, to 242, line 21.
That was
It's talk about one of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting. And then there's talk about Tick, who's Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume, rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
okay. So 241, line 1 through 242, line 14.
I have 242 line. Yeah, that's fine.
All right, so y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry, no. And then this hill, the next one I have is 243 line, I'm gonna say 1 because I don't have a line. 243 all the way to 248, line 11.
All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand, and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
Yes, Sean.
And I know y'all are doing the best you can, but
Yeah, she does not play with the nonsense.
So the next one that's not agreed to, that I can move on to, that I think is page 321, line 21 through 23.
all right, let me get there.
So.
Okay.
She's starting to get frustrated with them.
Is the objection speculation?
Yes. Like personal knowledge.
So here, Your Honor, he's repeating, this is a part of co-conspirator, this is the night of the shooting.
Mhm.
Murder Donovan Thomas.
Okay.
And he's repeating what the media told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mhm.
When you listen to Kenneth Copeland, it's not speculation, because this is what.
This is just the way he talks.
Because even when you look at line 24, he says, and when Thug was at Bentley's spot, which was more of an affirmative, this happened based upon what the media told him. So this is all in relation to what we argued the other day regarding co-conspirator.
Where is the state getting that he got this particular information from Mr. Garlington?
Because throughout here, he talks about, this is what the media told him when he got into the car with him and explained the murder to him once they got to the car.
I thought when they got in the car, all they had time to say was they shot nut, and then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to
Sky House or wherever.
And Nard got out of the car. And it's obviously, that's when more detail came in. That
Okay, and maybe you're understanding, where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that the media told him everything that happened that night. Now,
All right,
whether
well,
in the car or not,
I mean, if you show me the part where he says, D told me, what's his name? What's his Lil D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So, visiting.
20.
I'm gonna skip ahead. They muted it.
All right, so I see if we go up a page on 320, around line 9 through 13, or really 17, 18. That he's at least saying D told me this is all the people that were involved, and he personally knew it because he was with them.
if we go to page 318, Your Honor.
Okay.
Line 10.
Right.
And he says, this is what Little D broke the story down. He said, and then goes into what the media said, which is all the way to the Sky House, and so they rode past and met outside, they went somewhere to change cars, and that was it.
Mhm.
I dropped Shannon B on the Thug's house, and he continues to elaborate.
Right. So that's all what happened for him.
Right.
And I think,
That's why I didn't object now.
Right.
I'm objecting
So,
to the
I understand. So I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is. And I guess Lil D broke the story down, maybe.
So, our understanding from this interview is that the breaking down happened in the car.
Well, it doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
This, yes, from
Okay.
everything he says to, the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here's what he told me. Okay. All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it early, so this is the second time he tells the story, so for the purpose of this interview, Your Honor.
Okay.
He tells the story initially early on in the morning to Detective Gaither, Detective Dennis.
Yep.
And Detective. And then later they bring in Detective Thorpe, who was the homicide, the lead detective on the Thomas case. He reiterates the story again, with a little bit more detail in front of Detective
Okay.
Thorpe, so he's telling them all.
All right, and he's already said, I got it all from Lil D. Okay, all right, I mean, I think that is satisfactory, as, yeah, he had a source for this.
You gonna let it in, Judge?
The next.
I have 341 to 341, I think 19 to 350, 17.
Is that the whole meeting?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay.
And then 356, 9 to 19 was the same issue, I think.
Yes, I think it's, I have the full redaction, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And then so the next one I have is 361, line 1 to 362, 10. I don't know if we had agreed to that.
What I had as the final is that we were going to take out 361, part of line 16, so line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads Shannon shot up that tour bus.
She's finally talking into the mic. Thank you, Mindy.
All right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection. I guess the state doesn't do it that. Detective Thorpe, because you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut, Shannon shot up that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on and he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, I said, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Coleman doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. So he doesn't even respond to Detective Thorpe.
So maybe we could just take that part out then?
It's right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay, so why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever.
Okay,
10.
we got some stuff out. That's good.
Okay,
Yes.
all right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on, and then you can come back and put it all on the record.
Yeah, stop wasting time. Let's go.
I guess if you don't know, then we have to talk about it now.
$365.
This is why the judge is getting frustrated, guys.
Yes, that's in this. That's in dispute.
Okay, so John, on 365, 6 to 8, the context of this is Quindarius Zachary, also known as the other little dude, from Cleveland, he allegedly would buy, he's not a convicted felon, he allegedly buy guns.
Mhm.
At some point, he bought a gun for Kenneth Copeland. Allegedly, Kenneth Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shar stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Doug told him to buy the gun initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, it's, I don't see any indication that it's anything but hearsay. Here's the other thing. Quindarius Zachary is apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is, this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to when, how did this come about? How does he know Doug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down. Okay, so we'll need some foundational questions on that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it, but we don't know that yet. All right. Hang on just a second. Ms. Winfrey.
Okay, for those of you guys that are just coming in, we're getting ready for court on Monday, where the jury and Little Woody are finally coming back. What we're looking at right now is we're looking at pieces of evidence from Little Woody's testimony when he was talking to detectives. We're looking at all of that footage right now, and the prosecution and the defense are agreeing on what can be shown to the jury. So, you know, Whittaker is getting a little frustrated because both Max and Simone should have gone through this already. They should have a list of what is at issue, what they're arguing over, and you know that they also have another list of things that they've agreed upon that is coming out, that is not going to be in front of the jury. We're going through it one by one, and it is a painstaking process, but it needs to be done before Monday. It's a little quiet. So.
There was a portion of, so page 375, line 17 to page 376, line 9. The state only had an objection to line, page 375, line 17 to 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in.
I don't have a problem with that. and then 375.
All right, so hang on. So all of 375-17 through 376-9, there's no objection to, is that right? Is that right?
Coming out.
Okay. Wait, coming out or staying in? Y'all seem to be
Agreeing that it
saying,
comes out. We're agreeing that it comes out.
Wait, hold on.
Oh my God, such a mess.
You said 1 through 9, Your Honor?
no, I'm saying what you said.
Oh, sorry. I thought I
You
heard
said
one.
375 line 17 through 376 line 9. Are you agreeing that all of that is in or all of that is out?
Everything from 375-20 to 37, everything from 375-20 to 376-9 is out.
Out, okay.
I agree.
All right. All right, what's next?
I have 378, 1 through 8.
You said 378, 1 through 8? Yes, that is.
Agreed, out.
No, that's in.
Oh, okay. All right, tell me why that's in. Oh, I see, that's not the detective saying 7 through 14, that's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's to comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's going to tell, who's going to give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be admitted.
What's your script say?
Your Honor, this is a portion, if you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Ken Copeland's response, beginning on page 378, line 1, put it this way, Thug and them already knew those 4 right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and slipping my mind, who's the 4th person. And he says, I don't know about doo-wop, but them niggas not going to tell. That's why they're not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody told us, you feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And so who will protect the enterprise. And that's what we believe he is telling them, like, these people are not going to talk about our activity. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEBES 742, Fed 3rd 487, which is a 2014 case. And
Sorry, just tell me that whole side again.
Sorry, and if I went too fast, I apologize. United States v. Reeves, 742, Fed 3rd 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would a jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay, that makes a lot more sense. Okay.
It's a pretty slow process, guys.
All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, I mean, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have that's in conflict was page 386, line 20 through page 387, line 12. And
This judge is thinking about lunch. She's like, is lunch ready?
Is that in dispute?
yes, Your Honor.
Okay.
I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts explaining he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like,
And the he he's referring to is Donovan Thomas. So
And I agree.
okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Taylor Copeland and Donovan Thomas are cool with each other.
yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up. Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purposes of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
So where do we land,
I mean,
Judge?
they make their point without, the point that they're claiming to be trying to make is made without that last
I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah, so when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
But the only way it provides context.
Is if it's being offered for the truth, right? I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas. That Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct,
And
whatever.
Okay. But not for the truth of whether he's actually going to holler at him. Right. All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in.
All right. That was a hearsay statement. She's allowing
All right,
it in.
Let's take a lunch break. I know the lunch is here for the defendants. So let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20. 1:20. Will that be enough time? I'm asking the deputies. Yep. 1:20.
All right. That concludes our feed, guys. Look at that. So a lot going on in the courtroom this morning. For those of you guys that are just now joining us, we've been watching it all morning. I started us from the very beginning all the way up until where we are right now. So they are currently on a lunch break. I'm going to go through all the super chats. I did not have a chance to read them all, and I do have some cash apps here as well. So they are coming back around 1 o'clock. So here's the thing. Monday is a big day, right? We know Woody's coming back. We know the jury is coming back. And that is why we are going through all of these pieces of evidence right now to make sure that these things are okay. They're clear. The judge has ruled upon them to put them in front of the jury again, right? We know that Woody is uncooperative, and it's kind of the reason why we're doing all of this right now, because if he's going to give Simone a hard time, she's not able to get information out. So now, instead of having Woody testify, he's still going to be there to testify. And while these videos are playing, he's going to be on the stand. All right, so we're going to see him on Monday. Now, he has been busy. We've all seen that. He's been all over the place, all over the internet, and not really talking about the case as he shouldn't. But at the same time, we're looking at all of this play out in real time. These jurors and even Woody, they have not been in the courtroom in like a month because we needed to go through the whole process of getting Judge Glanville removed and putting a new judge on. And now this new judge has to be brought up to speed. But do you see how painstaking it is? I will say, I've been watching it throughout the week. Today is Friday. She's done an excellent job as far as speeding things up. She's even telling them during this lunch break, both Max and Simone, right? They need to have a list of what they agree that is coming in. But in order for this day to be productive, she wants them to come with the list of things that they need to argue about, the things that they disagree on. And she wants them to be prepared to tell her why they disagree on it so she can rule upon it. Okay. So we see a big difference as far as her and Glanville, as far as efficiency. Okay, so that's a really good thing. But at the same time, I'm sure you guys have noticed it is a whirlwind of a difference, Let's catch up with some super chats. And, Lead and I are not going to be streaming on Monday. So if you guys want to watch the trial, I will be here first thing in the morning, 8:45 Eastern. So I'll be streaming all day with that one. For today, we're going to see how the day goes because it is a little bit tedious, it's slow, right? Because they have to go through each piece of evidence. But you guys know me and my team, we like to, you know, summarize stuff for you over the weekend and get you a nice little brief recap video. So we're going to be working on that too. Let me come to you guys in the supers. I think I was right around here. Shout out to Danielle, who became a member. Thank you so much. Welcome to the community. I feel like you've been a part of the community forever, so it's really good to see you over here. Shout out to E. Capone, who's been a member for 5 months. He says, AV, bon dia, what it do? Good morning to you too, sir. And then D, I just skipped you. Dee sends $5. She says, AV said, Lee, just stay under that blanket. I got this. I got this. That's right. That's right. I do this because I love it. You know, I really enjoy explaining how the law works to people. And, you know, I like trial streaming too. It's really fun. It's really fun. And I need to do more of it over here on my side. So I'm super pumped. And then, you know, on top of that, we got the studio finally set up. I'm going to spend more time on it this weekend, getting everything up to speed. It's half of the lighting system on that side of the room is not set up yet. So I'm going to really spend some time doing that this weekend. But thank you so much, Dee. Shout out to the International Quiet Storm with $20. Says the West Coast never sleeps. Yeah, listen, he left this around when I started at 9 a.m. It was probably 6 a.m. on the West Coast. So shout out to the International Quiet Storm. I appreciate you, brother. Hope you're doing well. Big shout out to Full Drinking and Half Thinking. He gifted 10 AV to the 7th Power memberships. He's been gifting memberships all morning. So remember, if you got one from him, please say thank you to Full Drinking and Half Thinking. Super, super generous of him to make sure y'all got memberships. I don't lock people out yet. You know, your girl's growing. I don't lock people out yet. But just keep that in mind. You're going to want the membership. I keep you guys in the loop. You know, I poll my members all the time. I ask you what you want to see. We have a really, really good community over here. So thank you so much for gifting those memberships, Full Drinking and Half Thinking. Shout out to IG with the $4.99. IG says, seems like no mistrial. Judge looks like she will deny the motion and continue the case. Yes, I think that she is going to continue the case. There are a few motions that have not been considered yet. One of them is, I think Doug Weinstein's, there is a motion for a mistrial floating around there. She did say that she would entertain the idea. So that's why all eyes are going to be on this case on Monday. It's going to be interesting. It's going to be interesting. But right now, it's business as usual. We've picked up where they left off. And this is where they left off before Glanville got recused. I don't know if you guys remember it, but you know, it's so long ago at this point. Max and Simone were doing this right before Glanville got removed from the case. Like they've been doing this for weeks. So it is interesting that they were not ready or prepared. Shout out to Audrey with the $4.99 says, hey, AV, I'm loving my Woody tee. Yeah, that's right, guys. I have Trial Watch merch. If you're interested, there's 2 shirts. I'm going to be wearing them on Monday. I got my I Don't Recall shirt. So that is ready. And there's also the What You Mean shirts. You know, a lot of people are like, does Woody get these proceeds? Man, Woody is on Vlad. He is making his money. Or I think Vlad TV asked him, but he is, he has a really high fee to do interviews now. So Woody's getting his money. He is getting his money. All right. But if you're interested in the Trial Watch tees, the link to that is in the description box of this video. Grab it over the weekend. You know, it's super simple. It's very cozy. I try these products out before I recommend them to you guys. And shout out to Audrey, who has picked up her Woody tee. Shout out to D with the $4.99. It says Fulton County, where is the compelling evidence of drug trafficking, gun running, or murder by the state that justifies a RICO? This is a good question, D. Because that's the thing, like, you know, this evidence is pretty weak. Because really, what we've been going through all morning is discussing hearsay evidence. Little Woody telling what other people said to him all morning is hearsay. And Max raised a good point because he's saying that it's almost sometimes it's double hearsay because he's getting information about Shannon from all these third-party people. But it's like, what? And D has a good point. What evidence do you guys have that links these people to the crime? That's what we want to see. Not just Woody telling on people. We want to see the evidence. Where is it? So D has a really, really good point there. Thank you so much. Shout out to Buddha Belly with the $5 super sticker. Thank you so much, Buddha Belly. Appreciate you, sis. Thank you so much for that one. Shout out to E. Evans the Third. He became a YouTube member. Welcome to my community, E. Evans the Third. Look at that. That's tradition. That's heritage. Love it. Love it. Thank you so much for becoming a member. Shout out to Dave Olson with a $9.99 super sticker. Thank you so much, Dave. You rock. Thank you. I really appreciate that. And guys, you see your name. You see his name. The stream sponsor, HVM. He dropped $200. I did read this one earlier, but I do want to catch this one where he says, P.S. close. Congratulations. He and I know what he's talking about. But thank you so much. I'm really happy for you, and I'm happy that that took place. Thank you so much, HVM. And if y'all could do me a favor one more time, because I'm reading this one right now, if y'all could type HVM in the chat, that would mean the absolute world to me. Thank you so much, HVM. Shout out to Rod with $9.99, says 80 Hilton spitting bar. She is not afraid to use the N-word in that courtroom. Max is like, I'm just gonna use the term N-word, but Hilton has been reading these transcripts and, just saying it verbatim. So pretty interesting. Thank you so much, Rod. I really appreciate that one. Shout out to K Snap Cook with $1.99. Says, thank you, AV. Thank you. Thank you so much. Look at that. We got a lot of you guys joining and becoming members. I got time today. Oh my God. I love that name. I got time today. Became a YouTube member. Welcome. I'm so appreciative of you becoming a member, and I like your icon. That's cool. It's almost 12 o'clock. It's almost 12 o'clock. I got time today. That's cool. I love it. Shout out to Jamal, who says I don't recall with the $2 super chat. Thank you so much. Full drinking and half thinking. Again, gifting the memberships. He had gifted 10 before. He dropped another 5. It's super, super generous of him. Monique joins the community. Welcome, sis. I love that. Look at that. Full drinking and half thinking again with another 5. He's given out 20 memberships. Thank you so much. Full drinking and half thinking. Shout out to Michelle, one of my faves. She's been a member for 4 months. She says, I do not completely understand, but there is no reason that any of the defendants should not have reasonable bail. Love your insight as always, AV. Yeah, this is a good point, Michelle. There was a few motions earlier this week where some of them wanted to come out on bond. I know Young Thug reapplied for that, right? Judge Glanville denied that motion, and Brian Steele put in another one for him. If you guys remember, I think the very last time I streamed, it was last Saturday, I think, we went through some of those pending motions that she needed to rule on. So I do remember seeing a few of them asking for motions for mistrial and a few of them asking to come out on bond. And I believe that she denied some of those motions. Yesterday, we were not in court. And, Doug Weinstein had started the morning saying, hey, what's going on with that? I haven't seen copies of these motions that you just ruled upon, but she has denied bond for a few folks so far. So super, super interesting. She wants this trial to continue, and, they're going to pick it up where they left off. And that's what we've been doing. So thank you so much, Michelle. Shout out to Street Elevation with $4.99. Says, do you think they will win at appeal based on how messy it is? Well, it depends. My criminal law professor used to say that all the time. He says, it depends are 2 sexy words, right? It depends. If they bring this up on appeal, because here's the thing. They're all in jail now, right? The most important thing for these defendants is their freedom. They want to come out. They don't want to be in jail. They want an acquittal, right? So even if it, worst case scenario, we're not going to know for a few months, because if this trial is going to continue well into 2025, you have to wait for the case to end before you can appeal it, right? So these guys are going to have even more time on top of that. So it's interesting, but they could win on appeal if it goes up there. That's going to be very, very far from now, right? So great question, Street Elevation, and thank you so much for the super chat. Shout out to Michelle, who hits me with the $2. She says, shout out to HVM. Thank you, Michelle, and thank you for thanking HVM. That was very sweet of you. Shout out to Black Butterfly with the $1.99 super sticker. Thank you so much, Black Butterfly. I like your picture, by the way. And she is back, and she says, "Go AV7. I love your platform, girl. I love you back. Thank you so much. Thank you. And then lastly, shout out to Cash Money Cass with the $4.99. She says, what Skittles blazer will Love wear next? Cass, That's funny. Because yesterday she was wearing, was it yesterday? It was Wednesday. She was wearing green. Do you guys remember that? She was wearing a green blazer with green nails. And then today she's wearing a bright pink one. And it's like, all right, what is happening in this closet? And Cass, we have to grab some of the sisters from the chat and help her out over there, because I don't know what's going on in that closet. Something is happening. It's interesting. It is interesting. Thank you so much, Cass. Shout out to Michelle, who gifted one of you guys an AV to the 7 Power membership. If you received a membership from Michelle, please tell her thank you. And you see her in the chat. She is very, very active, and she's giving you the same experience that she has over here. So I love that you co-sign that, Michelle, and you're gifting a membership to someone else in the chat. That's very, very sweet of you. Shout out to Real Talk with Retta, one of my day ones. She has been a member, one of my first members I've ever had on this channel as I've been growing. She's been a member for 14 months. She says, thank you, AV. You always exceed our expectations. That makes me feel so good, Retta. You have no idea. I moved from Atlanta to Boston, guys. Like literally the moving truck was here on Tuesday and there's boxes everywhere. But streaming and hanging out with y'all just means so much to me. It's a lot of fun. I love doing it. So, when I see that acknowledgement, it really, really means a lot. So thank you so much, Retta. I appreciate you. So appreciate you. Coming over to the Cash App side. Let me make sure I grab all of these. Let me see. I did see one from, where'd it go? This was a long time ago. It was earlier. Oh, because I'm in the wrong email box. There it is. All right, here you guys are. All right, shout out to Chris. Oh my God, CW, Christopher Williams. I haven't seen you in a grip, brother. He sends me $20 on a Cash App. No comment, no question, pure love of the game. Thank you so much, Chris. It's really good to see you. It's been forever. Hope all is well. Full drinking and half thinking hits me with $25. He says, morning drink on us. Thank you, thank you, thank you. Listen, and that's the thing. I've been sitting here since earlier. The ice in this iced coffee has melted. It has been a long morning. Shout out to Beth in Seattle with the 10. She says, for your hard work, love watching you. Thank you so much, Beth. And you've been really holding me down. I appreciate you, Beth. Full drinking and half thinking again with $10. Says we launched last week, got 2 streams up. Full drinking and half thinking is a content creator, guys. And if any of my mods are around, and if you want to drop your link, Full Drinking and Half Thinking, we will absolutely give you a follow. We'll shout you out. If y'all want to check out Full Drinking and Half Thinking, drop your link in the chat. But congratulations on your content creation journey. That is super, super awesome. And welcome to the dark side, as I like to call it. Shout out to Caballo Escoto with $25. Says Full Drinking and Half Thinking, same people. Oh, okay. Interesting. Okay, thank you so much. Shout out to Dylan with the $5. Says gang, gang. Thank you, Dylan. That was super sweet of you. Shout out to Caroline with $10. Says great job. Thank you. Let me see who else we have over here on this side. I think I saw one that came in. Shout out to E. Evans III with the $5. Says love hearing you talk law. Awesome. I'm glad that y'all like it. Well, listen, they are off for lunch. So I may or may not be back for the lunch break, just because I got to get my editing team up to speed to do some content for y'all this weekend. We're going to do a recap before Monday's case, or the case resumes on Monday. I will absolutely be here on Monday to stream. So we will be back to watch more Woody shenanigans. We'll see how Judge Whittaker is going to do, like how she's going to do with him. Like, I don't know. Is she going to check him? What do y'all think? Do you think she's going to check Woody? I don't know if she will. I just know that some of the shenanigans, they need to stop. But let's see how she's going to handle that. Shout out to Mindy with the $19.99. Thank you. She says, AV, you rock. Love all of your discussions to help us understand. Thank you. Thank you so much. And Mindy, thank you for the compliment on the logo as well. That's actually one of the projects that I need to do. So that logo that y'all see, I actually have a sign that, you haven't seen me stream in a studio in a little while, but I need to put that sign back here. So by the time we are back on Monday, the AV logo will be on the wall. I can't wait. So thank you so much, Mindy. I really, really appreciate you. Wow. Did I miss a few of these? Did I miss a few? Oh, no. Sorry, these lights are in my eyes today. I'm all over the place. I'm like, did I miss some? Shout out to KC Crazy with $9.99. It says, have a great day, y'all. KC signing off. All right. Casey's letting us know, like, here you go. I'm out. I'm out. But thank you so much, Casey. Really, really appreciate you. Shout out to Candy Yates, one of my faves. $19.99 says, hey, AV, it's super fun hanging with you, sis. You're the best. Thank you so much, Candy. You are the best. Really, really appreciate you. And then Real Talk with Retta just hit me with the $20 on the Cash App. She says, love and hugs. You make me proud. You make me proud, Retta. Like you know, this content stuff is not easy, but I'm learning as I go. You build it as you fly it. Shout out to KS. Shout out to KS. All right, guys, I'm gonna head out. We will be back. May or may not be back today. You know, we'll see. But if not, I will do a nice little recap for you to kind of explain the rest of the motions that came out. All right, y'all. Have a good weekend. Stay safe out there. See you in the next one. Bye.